Okay, just so everybody and we can kind of try to stay on track today. Everything is a little bit messed up because we took so long on the rules calendar today. So the speaker actually pushed everything back until 1:30 as our official start time. We are going to suspend until a few more of our members kind of straggle in. I realize it's going to be everybody is kind of like myself. I'm meant to be at 4 different places right now, so 'tis the season. And but we are going to suspend for probably maybe another 5-10 minutes. Let a few more of our committee members come in, and then we'll hear the presentation from our juvenile court judges. So that's where we stand. And if y'all just want to be at ease for maybe another 5-10 minutes, we'll start the meeting. Oops.
Do you want me to hand out either of these, or?
We'll hand out the bills when David comes.
Got it.
And after the juvenile court judges are presented. All right, we're going to go ahead and get started with our judicial juvenile committee meeting. We're going to ask our juvenile court judges if they would to step forward and start their presentation. And y'all can either present from the podium or you can present from the table. We will have a sign-up sheet if anybody wants to. The only bill that we're going to be contemplating today is House Bill 253. It was David Clark's bill that we talked about at length yesterday. So if anybody would like to make a comment on that bill, a public statement about that bill, please feel free and let us know. But otherwise, that's the only thing that we're going to be hearing today after we hear from our juvenile court judges. So
Sheet's over by the computer.
the sign-up sheet is over by the computer. So welcome, and y'all just introduce yourselves and just kind of take it from there. Thank you.
Thank you, Madam Chair. I guess I'll start. I've got the microphone pointed toward me. I'm Judge Tom Parmer. I'm the juvenile court judge for the West Georgia Circuit, the newly created West Georgia Circuit. I was a juvenile court judge in the Coweta Circuit since 2013. I'm moving in my 12th year presiding in juvenile court. With me, and they'll all introduce themselves, but I just want to go ahead and say, since I don't just talk over, this is Judge Monica Wilburn from the Houston County, or the Houston Circuit. We have Judge Jeremy Clough from the Enoda Circuit, and we have Judge Shay Young from the Macon Circuit. And so I think what we had decided to do was maybe make a short presentation, see if there are any questions, and then if we need to elaborate on anything y'all are interested in, do so. So I don't know, Judge Wilburn, do you want to say anything?
Okay. So just to stay in line with that, my name is Monica Wilburn. I'm the Houston County Juvenile Court Judge. As I'm sure you're going to learn, a lot of the Houston County juvenile courts run very differently throughout the state. Our county is a rather large county, at least probably not compared to Atlanta, but for Middle Georgia, we have a population of approximately 180,000 at this time. I am the only sitting juvenile court judge. So at this time, the way it works is I've been on the bench for approximately 4 years. Before that, I served as our Warner Robins Municipal Court Judge and also a Magistrate Court Judge. We here in my particular circuit, we do have a clerk. I also have about 4 support staffs to help me with my dependency, which are our abuse and neglect cases. At this time, we have approximately 178 foster care kids. We have approximately 40, it's called family preservation, and that simply means if there was a family member able to take the child who is subjected to abuse or neglect. We handle all of our delinquency cases, that's children 17 and under, who may have committed what is considered a crime as an adult. We handle truancies, we handle CHINs, which is a child in need of services, and we also handle all traffic violations. Program coordinator for throughout my county. If there's parents who just simply feel that their kids are not necessarily committing crimes, but are on the brink of that, runaways, we coordinate any programs that have to do with that. So my 4 support staff help navigate that, in addition to being the main communicator between our attorneys, filing documents, and making sure that my calendars can run as efficiently as possible. Unfortunately, at this time, or fortunately, because I absolutely do love my job, but we are very busy. I pretty much hold court Monday through Friday, and we just designate set days. So Wednesdays and Fridays will be my abuse cases, and then Monday, Tuesdays, and Thursdays can be my delinquent cases, and we throw in truancies or any type of traffic violations that fall in. So that's how our particular circuit runs.
In the West Georgia Circuit, and with the new circuit, I've been the presiding judge in Carroll County for the 12 years I've been on the bench. I just took over Heard County, and they're 2 very different counties. I was born and raised in Heard County. I've lived in Carroll County my adult life, so I'm very familiar with both of them. In Carroll County, well, in the circuit period right now, I oversee 203 children in foster care, but 189 of those are Carroll County foster care children. 14 of those are in HERD, just to show the difference between the two counties. I also oversee 14 current family preservation cases where children are not in foster care but still involved in the dependency court that actually is filed by the Department of Family and Children Services or the division. I also have a number, probably, I did 2 this morning before I came up, but probably 10 private dependency cases filed on a monthly basis where relatives or others are filing, alleging children are dependent, and we move that through the court system. I have 2 accountability courts. I have a family treatment court. My family treatment court has currently 57 participants in it. It's a large court. It makes for a long day, but it's an extremely rewarding day. I guess I took some stats regarding my family treatment court, and I'll do a shout out to family treatment courts. It's something I'm extremely passionate about. Currently, of the 57 participants, 30 of them have full custody of their children back. They're not in de facto custody, they're not in a relative custody. The parents are involved in the program and have custody of their children. I have an additional 7 who the children are on trial placement with the parents. They have physical custody of the children, they're in the home and living life as a normal family. In the last 24 months, I've graduated 30 people from my family treatment court. It's a successful program and something I love. I have a plan of safe care program. That is a program that's funded by Department of Human Services to provide programs for mothers with substance abuse issues, both before giving birth and up to 2 years after that. I have currently 20 participants in that program, and again, that's I guess a labor of love. And we call it A Mother's Love is the name of our program, and something that's really exciting when you see a mother. I just had, to delve into a story, a young mother give birth to a child at Tanner Medical Center that had an open defects case. Because of that program, after giving birth, she and the child went to a evidence-based residential program. Our staff actually helped transport them there. She's in the program with her child. While it's an open defects monitored case, child never had to come into foster care. Child was born happy, healthy. Mother is clean of drugs, and child is clean of drugs. In delinquency, which I oversee also, obviously, I have 54 children on probation. I oversee 8 committed youth, 5 designated felonies. In Carroll, I have a misdemeanor diversion program. I have a county employee, not a DJJ employee, who oversees misdemeanor cases, and I have 21 people he currently oversees. In CHINs, last year I had 191 CHINs cases filed. Of those, only 22 actually came before me and were adjudicated CHINs. 90% of our cases are diverted to a pretrial grant-funded diversion program where they get case plans. The county provides me a full-time CHINs coordinator. She currently has 81 different cases in front of her in different stages that she's monitoring. And then I have a juvenile mental health court, accountability court for juveniles. I have 11 participants currently in that, and we have 5 in the assessment program where they receive intensive services for children with diagnosed mental health needs that have come in either through CHINs cases or delinquency cases. We adjudicate them as either a delinquent child or a CHINs, a child in need of services, and then prior to any official final disposition, they're placed in this program, and if they successfully graduate from the program, we dismiss the underlying charge. So that's kind of a breakdown of what I do, and I also am on the bench trying, most weeks I'm on the bench 5 days a week, especially with HERD. But a change in mine is Carroll County has just authorized me to bring on a part-time associate judge who hopefully in the next 2 months I'm going to do that. And that is going to, the 2 counties are working on an intergovernmental agreement to fund that so that I can get some help in covering Heard County, which is going to be difficult without some help in Carroll.
Thank you. How are you, you mentioned that you were going to have a new judge. I know there's a lot of variation throughout the state as far as how judges are chosen. So could you kind of walk me through kind of how you were chosen and how you plan on choosing your new associate?
Yes. My new associate, under the juvenile code, there are really two types of judges. There's a juvenile court judge, and then there's an associate judge. The juvenile court judge is the, like us, that's appointed by the Superior Court judges, can be full-time or part-time, part of state retirement and a full judge. There's also a provision for an associate judge. This is going to be an associate judge. Will be paid for and approved by the county commission. I will say I consulted with the Superior Court judges before making the decision and going before the county commission, but it will be a judge who is appointed by me and then serve at my pleasure, or if there are more than one full juvenile court judge, serve at the pleasure of the juvenile court judges. So that's it. I mean, I worked on this, worked with the county commissioners on the funding of it. I will say a great benefit in doing that is the juvenile court funding grant money, which doesn't go to the associate judge, but goes to the county to assist in them paying me and the counties now of the circuit and paying me for mine. So it makes it easier on me to work with them to then find other funding for this associate judge. But I went before the county commission last November. They approved a certain amount of budget for a part-time judge. I advertised that through the County Bar Association, sent an email to, frankly, every lawyer in the circuit. I've interviewed for that and plan to make a decision in the next month as to the juvenile court judge.
Okay. And tell me a little bit about kind of the process that you went through as far as was there any kind of case count or anything like that whenever you were going before the county commission to prove that you needed help?
Yes.
How did you go about doing that? And is that something that you devised, or is it something that is uniform throughout the state?
I would say I went about it two ways, both numbers that I pulled and then came from the state, and that came from records from the administrative office of the courts, both in studies I had seen. One of the juvenile court judge who sits primarily in Coweta County, who used to be in the same circuit, had a study done a couple of years ago, and Coweta County just created a second judge in that. And so I did borrow some of those numbers, which was a request from AOC, so I had that report. I also then pulled numbers from counties of similar size, and I will say I pulled Houston County, where Carroll County is 110 to 115, I think now. Heard County's less than 120. So I looked at similar circuits and all. And so looked at their numbers, but they're available through AOC, and then I talked to some of the judges. And then I took those first to my Superior Court judges, and frankly, to see first as to how they wanted to go through it. Did they want to declare a juvenile court judge and maybe a part-time one and go through that process, or do it through the commission? We agreed that for what I needed now, that it would be the associate judge, and then I provided that information to my county commission. So that's kind of not an official process, but there is an official process. It was done in my neighboring county, and so I used those numbers as to need, because Carroll County was included in the study for Coweta of their need for a judge, and our numbers were similar, or frankly greater in some. There are more children in care, more dependency cases in Carroll than Coweta.
Okay, all right. And do you ever sit for your Superior Court judges?
I do not sit at all. Like I know there's some juvenile court judges sit and cover a calendar. I'm not asked to do that by my Superior Court judges. In fact, during after the COVID and all, when they were had funds and were looking for people to help them out covering some calendars and had some funds to accomplish that, and I say this in appreciation of the working relationship I have with my Superior Court judges. We met, and some of them talked to me about time I would have. They knew my calendar. They looked at my calendar and frankly said, don't be offended, we're not going to ask you to do it. So I have an extremely good relationship and a long-term relationship with my Superior Court judges. The only time I sit as a Superior Court judge is specific cases either transferred to me to make decisions as to the issues of custody, or occasionally in a case that is very related to something I have, they will appoint me as a Superior Court judge pro tem to hear that case. But as far as my docket is concerned, and again, they work very well with me. They know what I do and what my expertise is. Most of what they send to me is things that are very related or actually related to dependency, directly related to dependency cases I already have.
Okay,
But that's
all right.
me.
Y'all have a question, number 12?
Yes, thank you, Madam Chair. And Rockdale functions the same way. We just went through the process of getting an associate judge for our probate and our juvenile justice. My question is, based on the two of you all, and you're doing more than one county within the circuit, correct?
Yes, I am.
Okay.
As of January 1.
Okay. I guess my question is, the case log, has it increased since COVID, or do you see a diminishing of it? I mean, what's happening? I know you can't answer for all 159 counties or the judicial circuits, but can you give us some type of overview of what's happening out there in the juvenile courts?
I will say from my personal experience, first just case count, immediately after COVID, there was probably somewhat of a decrease, not a great decrease in the dependency cases, and there was a greater decrease that I saw in delinquency cases. But that was very short term. Now, as far as my dependency count and my delinquency counter, they're equal to or greater than where I was pre-COVID. So it really hasn't affected my calendar.
Awesome.
And for Houston County, we had the opposite. After COVID, there was a great increase. I don't know if being in those close quarters, people started taking their rage out on their family. But we are in a unique position, and perhaps it's for the entire state of Georgia, but definitely for Houston County, where we have grown tremendously. In fact, we're in a slight transition phase, I would say. Our Superior Court is how I was appointed. I do not go different circuits. It's just Houston County for me. And when I first took the bench, it was immediately after COVID, and there was a discussion with my Superior Court judges about me possibly sitting on family court cases, because a lot of my Superior Court judges would prefer not to have to see that. And then when we went through our numbers, they said, in fact, you probably need assistance, and there's no way you would be able to do that. Now, they do also transfer down any cases that originally were dependency in front of me, because they just said, for judicial economy, you've already heard some of the facts. You'll probably be in a better position to hear custody matters. Our Superior Court has just added, literally as of January 1st, a fourth judge. They said they added a third one in 2007, and that's when I moved here with my family, because my husband was in the Air Force, and Houston County is a huge Air Force community. So since we just got the fourth judge, I have a great relationship with my Superior Court, but also with my county commissioners. So we're right now in our budget phase, and I am also a department head, so I have to talk about our budget for the next year. So I have said I recognize that our Sheriff Talton has just passed on, and he was our longest sitting sheriff, so we have a brand new sheriff who's talking about reshaping our bailiffs and our security system. And we now have a fourth judge in our Superior Court. So I've told my commissioners I'm not asking for an associate judge right now. I know my caseload is increasing, but we have too many things changing right now. But anticipating in the future, it may be something we have to look at. And for our county, I gave them the numbers and the cases we have. But on top of that, if we add an associate judge, that means adding bailiffs. That means adding more support staff. That means adding more equipment. And it is not something that can happen overnight. So I've started giving them the numbers in anticipation that in all likelihood we will end up where we'll need at least two judges sitting in my juvenile court.
Thank you.
Okay, all right.
Can I actually, I apologize, but there's one thing that I think, rather than COVID or something like that, that I think affects all of us, and we as judges talk about this, that I'm seeing that's increasing numbers I'm dealing with, and we all are. And that is a, not move from, but on top of the ongoing methamphetamine epidemic that affects us very much, and especially on the dependency side, but a move to, even in my community, and increased addictions to heroin and then fentanyl, and shocking actual, not just fentanyl being laced with something, but I'm dealing with people now who are actively seeking out and are addicted to fentanyl, and that is what affects a lot what we deal with and the children we have coming into care, and then our reunification services.
It affects every aspect. It doesn't just affect our dependency and neglect cases, but it affects the truancy. It affects the crime that's going on. A lot of times my kids are raising themselves, and some of them are breaking in the cars or finding their families in gangs or the community. So definitely the drug push has definitely had an impact, because I then will learn that sometimes their parents are incarcerated for drug-related, or they're just not present because there's drug issues, but it definitely has affected all of our numbers.
Okay. One thing that you mentioned that you were a department head
Yes.
in Houston County. Are you considered a department head? Or, because we have had situations in the past where the juvenile court kind of fell under the Superior Court, so they were not considered a singular entity. And sometimes they would request resources, and the county commission would give them resources, but those resources would kind of disappear into the Superior Court kind of haze. So are you considered a department head, and do you deal autonomously with the county commission?
Yes, Madam Chair. There is Carroll County has a juvenile court department. I'm the department head. I have 11 full-time, 1 part-time employee under me. 6 of those are paid by the county, 5 in the part-time or grant funded. But yes, I'm the department head on that. In Heard County, there's no department. It's me. As far as the juvenile court, a lawyer last week actually made the joke of, I'm a sole practitioner judge in Heard County. I come down with my laptop, but it's a much smaller docket. So the Superior Court clerk and the assistant clerks are the staffing for that, but there's no, I deal directly with the commissioners, I guess, for any funding that's made, paying attorneys, paying guardian ad litem.
Okay, all right. So you both operate autonomously with your commission?
Correct.
With your county commission, okay. Does anybody, I'm sorry, I just kind of jumped in because I had questions. And, that's what I kind of encourage my committee members to do. Because sometimes it's very difficult to kind of circle back. So I'm sorry if I interrupted, but y'all, were you finished, or?
I just didn't want to monopolize, because I know we came down with all 6 of us, so I'll be more than happy to answer any other questions.
Any questions? I would say we can go into, and again, I don't want to monopolize or go into things y'all aren't interested in. Some of the topics like grant funding, what grant funding we get, more specifics on staffing, kind of specific numbers and things like that.
It'd be, and I'm not sure if they want to speak from back there to make it easier, because one great thing you did was choose more than one judge to sit here, because I even had an eye-opener just in our short meeting in preparation of coming up here on how different all of our, like you said, department heads, some of them are under the Superior Court, some of them are not, and it was eye-opening for me. I said, well, I'm glad we had this discussion before I'm sitting in front of the committee to be enlightened at the same time. So I don't know if it's a complete representation of how diverse the juvenile court is ran throughout the state, but it definitely will give you a little taste of it. So this is just a nibble of exactly how diverse it is.
Okay.
So I saw you move forward. I will switch seats, but if it's not disrespectful, if there's something we feel we can add, can we answer that from
Sure.
that back row? Is that
Sure. Hold on just one moment before y'all move around. Number 25 has a question.
Thank you, Madam Chair. Hey, thanks for being here. I'm a longtime educator and appreciate what you guys do and involved with you guys a lot. I guess two questions, one from a legislative perspective and then one was a past educator perspective, semi-legislator too. First, I sponsored a bill last year, got across the board, a drug called Kratom. You mentioned different drugs. Was that prevalent at all in the in the lower ages? It was a big deal in the drug court. I know that as a drug that people either got high or off on, and a lot of times people would try to use it to get off opioids, but it went in the bad direction. So I didn't know if that was the case in the juvenile courts, if you experienced that during testing and things.
I see kratom and testing issues in my family treatment court dealing with adult parent participants, and so I have seen kratom use. We've had to adjust our testing protocols in order to catch that and to deal with it. I have not seen it that much among juveniles, but I think probably one of the reasons for it is difficult to test, and so some of the tests that are used through juveniles, just kind of, for lack of a better word, dip tests and things like that aren't as quite as accurate as some of the things we use in a formal accountability court. We don't pick it up as much, but certainly among adults, and it has caused issues in our drug testing.
Okay, and second question, communication with your local schools. I know it really depends on the county you're in, the system you're in. How's that partnership? How's that communication with your local educational partners?
For me, and I know it's not this way, it's phenomenal. When I took the bench, and it's nothing, because when I took the bench, the judge before me, Judge Edwards, had sat on the bench for 25 years. So, and a lot of the leaders, school board, or the Department of Family Children Services had been there almost just as long. So it was a transition period. Just because no matter how hard I can try, I'm not going to be Judge Edwards. I'm a different person. And so I was a big advocate on the line of communication. So because I do not believe that we can make an impact on these families in an isolated position. So I called for community meetings with our school board and making sure Department of Family Children Services was there, that DJJ, the Department of Juvenile Justice, and all of us was sitting around the table and just would talk about in our community, what do we see as a major issue and how can each aspect of it touch upon that. And it is a fluid process. I will say this year, I know that my school board came to me and said one of their big issues is attendance and truancies at school. So we've just now rolled out a new process where every 2 weeks, it's almost like a scared straight, those kids who are not quite to the extreme of missing 90 or 80, but on the cusp of not, they sit in front of me and hear from me about what the potential ramifications can be if they get to that place. And then the school has their own programs going on. So it requires very close communication and working together. And if something's not working, because we're constantly looking at the numbers and seeing if it's an impact, a willingness to make changes. The parents, if they're the reason why the kids aren't going to school, that is handled in my county. It's handled at a state level in the magistrate court. But to me, we have to tackle the whole family. So when we meet with the school board, my magistrate court judge is there and my state court judge is there and their programs, and we're meeting with the school board to see how we can make sure we're all sending the same message and make sure that we're not double penalizing a family, but working together in a way to make it work. So I do one program of it, and then sometimes my magistrate and my school board is the main communicator about if it's making an impact and what else we can do to help them do their job.
Great, thanks.
Yeah, I love my school board.
A former educator always likes hearing that.
It's imperative. I'm not going to lie sometimes, and we had a little discussion about this, because the second a kid get in trouble, they'll be asking if they can expel them. But I tell them the judicial process is though set up in a way where sometimes information gets flushed out and it turns out this kid didn't do that. But if I ever, because we have the relationship we have, the legislator says Class A, Class B automatically. But depending on the facts, it requires that relationship and that communication, so I can make sure that a kid who really didn't commit something isn't expelled from school and then getting even further behind. Or if there's a kid that I have done, and my community have done all we can to get them to school. Are they a danger to the community, or is there something we can do that where you're not expelling them just because you found out? Because I just heard something about a leg monitor. I was like, well, on some of my runaways, when a grandma is saying I can't find out where my 13-year-old, I put a leg monitor on them, and I don't want that to be an excuse for them to be expelled from school. It's just so we know where they are and know that they're not being trafficked and know that they're still alive. And that requires communications with my community, with my officers. We're the only one in the entire state who have our own dedicated sheriff's department. We have a juvenile sheriff department. And so anything, I always tell my kids, it's like a village. Anything that you do, I know what's going on. So you can't get away with it. But it's because all of us know each other and we constantly are in communication.
Okay. Okay. Number 2.
Hey, thank you for being here. Thank you, Madam Chair. How many cases would you say are transferred from juvenile over to Superior Court, if you could give a rough number?
You mean on a delinquency?
Based on the hearing, after the first hearing?
We don't transfer a whole lot of them. I will tell you, my assistant district attorney files motions sometimes to have some of the more egregious offenses, shootings and stuff like that, especially if there was an injury or result transferred, but there's still a whole process that they have to go through and file a hearing. And I would say maybe in my last year, and I can actually say this, we've transferred 3 up to Superior Court. For the most part, we keep them, we'll handle it in juvenile court.
I would say and again, these are delinquency cases that are then, because of the offense, transferred to Superior Court to be treated as an adult in the Superior Court system. And they're asked for by the district attorney's office. I've never had one in Carroll County that the district attorney I've had one that they requested and then they withdrew because they decided not to. But that, though, is very different in different juvenile courts. So you will get a different answer depending on who you have. In some, it happens more routinely than the district attorney's office. So it's just just for Carroll County and the district attorney's office. I have a few that are transferred from Superior Court that were charged as adult and come down to juvenile court. I have one that I've got a hearing on tomorrow for that side.
Thank you.
All right. Seeing no further questions, I would like to thank y'all. And if y'all will just stay close in case we have questions. The podium is always available. If y'all need to kind of hop up and answer a question, y'all could always use the podium, because I will tell you that people who are watching online, because this is being broadcast, they will get mad at me if you don't use the, even though I can hear, they can't hear on the transmission. So y'all go ahead and sit down. So anyway, so that's why we kind of insist on the microphones, not because my hearing's that bad, but if you would, just please introduce yourselves just go ahead and get started.
All right. I am Judge Shay Young, and I'm from the Macon Judicial Circuit. And so Macon Judicial Circuit encompasses Bibb, Peach, and Crawford County. Houston County, where Judge Wilburn is our neighboring circuit. We used to be bigger than Houston. Macon did, and they are the fastest growing. So they have about 180,000 people now. We have about 156,000 in Macon. But Peach County is about almost 29,000, and then Crawford County is about 12,500 folks. I have worked as an attorney in all 3 of those counties, and so I come from the district attorney's office, which encompasses the same judicial circuit. I said I would never work with my husband, but I do. He is the principal at one of the local schools in Macon, and so we work pretty closely together on a lot of cases. In the district attorney's office, I was in the Crimes Against Children division initially, and so had a lot of victims at his school. And then I went to the juvenile division for 2.5 years before I took the bench. So that's just a little bit about me and my circuit.
I said you married well.
Madam Chair, representatives, thank you for having us today.
My name is Jeremy Clow. I'm the presiding juvenile court judge in the Oneida Judicial Circuit, which is Towns, White, Lumpkin, and Union counties. We're a small rural circuit with a population of around 100,000. I started my legal career there in 2003 after I graduated from Georgia State, kind of across the street here. I was hired as an assistant district attorney by then district attorney and now Representative Stan Gunner. And I worked for that office for about 12 years, the last 7 of it as the senior assistant DA over the White County office, where I focused on prosecuting serious violence and sex crimes. In that time, I prosecuted about 59 jury trials to verdict and appeared 3 times before the Georgia Supreme Court, and then became convinced that there was a need in juvenile court. I put my name in the slot after the advertisement came out. Several people applied. Several people were interviewed. I ultimately wound up being appointed by majority vote of the 3 Superior Court judges, among whom was then Superior Court Judge Stan Gunner. Right now we have a staff that consists of 1 judicial assistant, and I have 1 associate judge who serves 2 days per week, who is also a magistrate judge in the rest of his time. The way we were able to get that seat, which is county funded, is I simply approached the county commissioners, who all have to unanimously agree on such things, talked to them about the workload we had. I talked about the number of exhibits and the simple volume of paperwork that we had to manage. We also compared our circuit to neighboring circuits, and I think at that time we were the only one in the area that only had 1 judge. And candidly, it didn't take too much convincing because juvenile court had a reputation. The DA's office used to say that we were like the British Empire. The sun never set on juvenile court because we were simply always in court because we had so much business to do. The bulk of what we do is dependency, which is DFACS cases, child welfare cases, in addition to delinquency. We also have a family treatment court. We were one of the first 9 in the state, and so we were part of what in that community refer to as the KC9 courts that wrote those standards for the rest of the state when those were first canonized. As part of when we are a model court for the state of Georgia for family treatment courts, I serve as the FTC representative on the executive committee on the Council of Accountability Court Judges. I also sit on the funding committee. I'm vice chair of the data and research committee for CACJ, and I chair the next step committee, which is focused on implementing House Bill 873, which all were kind enough to pass through last session. Thank you.
I'm sorry. Bibb County also has a family treatment court. We just came under the Council of Accountability Court Judges probably about 2 years ago, a year and a half. Judge Clow's circuit is actually going to peer review our court next month. So we were initially under the county. There are 2 judges in my circuit. Our chief judge, who had been on the bench since 1997, just retired. And so I am the chief judge now, and I'm onboarding a new judge as we speak. So those 2 judges those 2 full-time judges handle all 3 counties. We do have an associate judge that previous Chief Judge Matthews did appoint. That associate judge has probably never been to the juvenile courthouse and handles all the Superior Court accountability cases and is paid through ARPA funds, I believe, from Superior Court. And so Bibb County does have a juvenile clerk of court. Our other 2 counties, Peach and Crawford, I have to work very closely with the Superior Court clerks. That has been a challenge, particularly with the data pool that the legislator that you all would like. I do have really good relationships with them, and so part of that has been me convincing them to allow someone from my office to input the data so that it can be pulled. And so that has certainly been a challenge. I am the department head in Bibb County, and so I have about 10 folks that work under me. And in the other counties, we have 2 folks who work both Peach and Crawford County. And they do the job of probably about 15 people in Bibb County. And so I work very closely with them, and I really promote having good relationships, not only with the county agents, the other agencies, but also with the county commission. And those two people have done a tremendous job of that. And so we are in the process now of starting a truancy court with the district in Bibb County, and we hope to be able to take that to both Peach and Crawford counties. And so we're doing some really good things. I really enjoy all of the people that I work with, and it has been it's been great for me because I do live in the community that I work for, that I serve. I see a lot of the children that I serve on the dependency side. My son does go to high school at my husband's school. He plays football. I work the concession stand, and so these children sometimes come up to me. They talk to me. I had one kid recently who came up to me while I was working the concession stand, and he gave me a big hug, and he said, you were tough on me, but I know that you did it with love. And that's why I do what I do, but that's why most of us, really do what we do. And I appreciate being able to serve in the community in which I live, so that I can see the results and the impact that I as a juvenile court judge make.
Okay.
As a mountain circuit, we basically have the north side of the circuit and the south side that are separated by the Appalachian Trail. That's more or less a dividing line between the two counties on the top and the southernmost two counties. The way our calendar is structured, we have court in every county every week. I drive a lot. We're on call 24/7. For the first 8 years, I basically was on call by myself and did not have a backup judge. I got called out on about every other anniversary. Christmas Day 2023, I was called to drive over the mountain and handle an emergency matter and got home about midnight that night. Deer season is a challenge, as you can imagine. Usually what I'm called out for is for the dependency removal order, which is when DFACS first makes a request to remove a child or children from their parents' custody. That first hearing after that has to take place within 72 hours. There's a school of thought that says the statute only requires that it be scheduled within 72 hours. But I believe the intent is that if somebody from the government is coming to someone's home and taking their children away, they have the right to come into court as fast as possible to challenge that. And I'm not criticizing the department for taking those children. It's my order that brought those children into department care. But I believe as a matter of due process, those hearings need to be held very quickly. And unlike some other classes of courts, because the way deadlines work in juvenile court, frequently they're in hours as opposed to in weeks, months, days, or years. So when COVID happened, outside of the two weeks we were shut down by the governor, we did not stop doing business. We handled a lot of cases by consent. We handled a lot of cases on the pleadings. We moved very quickly to virtual hearings, but we did not stop during that time frame. And we did not have a backlog of cases that did not move forward as they should have because of COVID. We simply continue to do business because these parents have the right to have their cases come to court, and these children have the right to have decisions made in a timely fashion. One of the things that we've seen change, when I first came into office, I established an on-call system, which means from that very first 72-hour hearing, when somebody comes in the courtroom, there's a lawyer there waiting for them. We qualify them there on the record. If they qualify, they receive an attorney right then, and we can have the hearing that day, as opposed to saying, come back next week and see if you can find a lawyer. We've got somebody there so they can have a meaningful hearing as quickly as possible. If that lawyer needs time to prepare, fine, we'll continue it. But we're sending them out with representation, the ability to come back and have a meaningful hearing. We have a bar we have a very focused juvenile bar. Oftentimes they're able to negotiate with the department to move those cases all the way through adjudication at the very first appearance before the court, which then gets us on the track to that family moving either towards reunification or towards whatever else needs to happen in that particular case. In terms of the workload, In all 4 counties combined, we have 133 children who are currently in DFACS care, either in foster care or awaiting adoption. There are 25 more who are currently placed with their parents under a protective order. All of those cases are required to continually come before the court at certain statutory intervals, either from 72 hours to 6 months. Most of the time, we see those cases about every 3 months or so. I asked our staff to look at the court counter from last year. In 2024, not counting holidays, weather days, et cetera, we had 248 work days. Of those 248 days, we spent 202 of them in court. Of those remaining 20 some odd days, there's mandatory training, there's continuing education, there's committee work and other things that have to take place. It's hard to capture what that workload looks like. So when people ask for a case count, we will absolutely do our best to provide those numbers. But simply saying the number of cases is not an accurate capture of what has to be done for those cases to move forward. A case could have 1 child, a case could have 6 or 7, it could have 2 married parents. You could easily wind up with 4 or 5 parents. You could have 9 lawyers in a case. Obviously, scheduling a case with 9 lawyers is going to be substantially harder than, for example, a criminal case where you have a public defender and a district attorney. And so one case is not the same as one other case because they vary in complexity. When I tried to capture those numbers for our county commissioner, what I looked at was the number of exhibits that the court had to consider in order to pass a ruling in a case, because most of the evidence in our cases consist of documents. These may be domestic violence assessments, these may be drug abuse assessments, case plans from the department, which the court has to review in order, or other documents like that. And I started tracking that in late 2022. In 2023, I read in excess of 12,910 pages of court exhibits in order to be able to rule in those cases. And I can't issue a ruling until I've read all the evidence. So sometimes when there are delays in court orders, sometimes that's why. We may have cases where there's 100 pages. It's routine in review hearings to have that many documents to read. Sometimes it's 400. I have seen it be over 1,000 in a single case, in a single hearing. Last year in 2024, I read in excess of 12,988 pages of exhibits. That's simply a lot of paper to move. We do not have a juvenile clerk in our circuit. We use the elected clerk of court in each of the 4 counties. We do not have a clerk who is in the courtroom with us when we have court. In 2 of the 4 counties, we routinely do not have any law enforcement present during court hearings. And in 2 of the counties, we do not have chambers. In one, we're in the process of getting chambers, but the juvenile chambers is in Lumpkin County. We go where we need to go. We have court where we need to have court, and we do it the best we can. But we do that with somewhat limited resources. One of the other duties in addition to court is, of course, the administrative piece. And I am the department head. We're coming up on budget hearings in a couple of months. Our budget has to be agreed to by all 4 of the county commissions unanimously. I sign every bill that comes through juvenile court. I read every entry. We don't pay bills we don't understand. When I first came into office, we had the phone bill billing things they couldn't explain. We had people billing for document destruction who were not actually performing the pickups they billed for. And when I moved into analyzing the lawyer bills, which account to about $500,000 per year, we realized that we had some attorneys who were billing $800 a month to make copies. We had some lawyers, I caught one recently, who was billing 33 hours in a day. Now that's a problem. That's a real problem. It's not my money, but I'm responsible for it, and so I need to make sure that I'm spending it wisely. That's why we look at every single entry, which works out to somewhere in excess of 10,000 hours of lawyer time per year, billed in 6-minute intervals. I read every single one of those entries because that's simply the right thing to do, to know whether or not they're doing what we're paying them to do. That consumes a large chunk of my time when I'm not in court, is the administrative duties. It simply has to be done. It's not frequent that I have problems, such as lawyers billing more hours than are in a day, but when that happens, it does consume a lot of administrative time.
Okay, hold on, just one, number 2, you have a question?
Thank you, Madam Chair. Do you utilize CASA or any other nonprofit organizations around your community?
Yes, we do. We use CASA. I'm pleased to report that 2 of our CASAs have been CASA of the Year. We have a wonderful program.
We also utilize CASA in all 3 counties.
We just, we just got CASA in Henry County, so I was curious. Thank you.
Mhm.
All right. Any other questions from committee members? Okay, seeing none, y'all can proceed.
May I tell one story,
Sure.
Madam Chair?
Yep, the floor is yours.
I just went over an awful lot of stuff and an awful lot of time, and I think anybody who's just heard the numbers would reasonably ask, why in the world do you do this? Do you even like what you do? The answer is, I love what I do. And here's why. So about probably 4 or 5 years ago, I handled a removal case. DFACS called me, they gave me the facts. I removed 4 children from a home in which they were being sexually tortured. It had been for years. I handled the case. It moved on as it does. Their abuser was later tried in an adjoining county. And I walked into the gas station one day and his case was on the front page of the paper. And so he was out of the case, so I could read about that portion of it without it being inappropriate ex parte information about the case. So I got the newspaper. I was familiar with the facts of the abuse. I won't get into detail, but it involved fire. It was the worst thing I'd ever seen. What I did not know until I read that paper was that when I gave the removal order, as DFACS was driving those 4 children away from that house, one of those girls called out the window, "We're free." And they were. And I was able to make a decision that pulled those children out of the hell that they would otherwise probably still be living in. And that's worth any number of Christmas days, any number of exhibits, or anything else, because they're free.
Yeah, sometimes we have to make tough choices, but a lot of times they're the right choices. Members of the committee, any other questions? Okay, seeing none, is there anyone else here to present from the Council of Juvenile Court Judges? Okay. All right. Well, thank you so much. I know you've given us a lot of information and a lot of information to kind of mull over. So I wouldn't be surprised if committee members reached out to you and had questions later. I'll certainly make sure that everybody gets your contact information. If you ever have any questions for us, feel free to reach out to either myself or the committee members. We'd be more than happy to chat with you or answer any questions that you might have. Okay? Well, thank you so much. We are going to hear from Representative Clark. He is going to continue his presentation on House Bill 253. The one that had the fewest changes.
This one right here, probably?
Yeah.
Okay, got it.
Brian is going to be handing out a copy of the committee sub. I'll be walking everybody through the committee sub. Representative Clark will be able to answer any questions that you may have regarding the policy. Okay, so just to kind of walk everybody through the committee sub, we are working from LC 481514S. We cut a lot of the bill known as Ethan's Law. Is there anybody in the audience that wants to speak on this bill that was not able to do so yesterday? Raise your hand or flag me down, or okay. All right, I just didn't want to exclude anybody from speaking that wanted to speak. So we are working from LC 481514S. We did strike a lot of the bill, but the main section 2, got curtailed to basically just prohibiting any kind of reunification or unification treatments, any of these camps from being ordered in the courts. And do we have an original?
I'm looking up here somewhere.
Give me the one.
Why?
That'll be an original. There you go. See? Occasionally, I get a smart one. So that was the change that was made in Section 2. Section 3. Okay. Section 3, we struck some of line 46 and 47. That now reads as family reunification or unification treatment programs or services means any treatment program or service that provides educational and experiential workshops and operates or utilizes private youth transporters or private transportation agents, as described in Code Section 1511 202.1. Number 12, you're flashing.
I was going to wait till you finish, but
Okay.
so we're no longer focusing on crossing the state line.
Well, we are still focusing on that, but we're focusing more specifically on the camps.
On the cap that you make. The
Yeah,
judge makes
but
the call.
by the camps we mean the the crossing the state line. Yeah.
Gotcha.
And we've actually added in some language not in the sub that has to do with the alienation portion of the as one of the major concerns that everybody had with the bill, not liking the alienation, even though it was, they were trying to reunify from parental alienation syndrome, but the fact that they basically plucked the child out from their home, their friends, their school, everything, the family, and then put them into this camp, that was not. So we actually, had certain things that will prohibit that. Number 17.
Thank you. You said there was some language not in the sub that was added?
Yeah, that we're going to be adding to, yes.
Okay. Are we voting today on this?
We are. There's just a statement. There's not much being added to the sub.
Do you know what the language is?
I do. I have it right here with Brian.
Okay. Can I ask the judges if any of them have seen this in their courtrooms?
Yes. We are hearing a bill on Ethan's Law having to do with parental cases where the judges have found that there is parental alienation syndrome, so to speak. And we are basically outlawing the practice in the state of Georgia, forbidding any judge from sentencing or having or court ordering any of these family reunification camps. A lot of them are out of state, or the majority of them are out of state. So, Judge Brown, I don't know if you want to speak as president of the council. Don't know if any of your judges have had experience with that, but
my name is Neil Bryant. I'm the juvenile court judge in Bartow County. I'm president of the Juvenile Court Judges Council. When this bill first came out, it was circulated among the legislative committee and the other judges. There was a lot of puzzlement about what this was. So I'd be shocked to find out that any juvenile court judge had ever ordered this, particularly in the case most of our kids are going to be in DFACS custody, so we couldn't do it without DFACS agreeing or paying for it. So I think a lot of these cases, and particularly Ethan's case, came about as a consent between the parents. The judge didn't arbitrarily do it. The judge just approved the parents' agreement to enter this. So I don't think there could be judges, I don't know what judges do, but I'd be shocked to find that this is a common practice at all. I know it's not used in juvenile court.
I have found 8 judges have ordered this in 8 disparate motions. They were all in Superior Court, and they were all ordered over the objection of the primary physical custodian. It was a situation where the primary physical custodian, had spent the majority of the time with the child. Maybe the non-custodial legal guardian of the child maybe hadn't spent that much time with the child in the last few years. So they actually came into court, petitioned for the judge to order one of these family unification camps alleging parental alienation syndrome from the physical custodian, and the judge ordered that the child be removed from that custodial parent to the parent that he or she was alienated from. And like I said, most of these camps are, I think 2 of them are in Colorado and 1 of them is in California.
Right, but all those were Superior Court.
All of those are Superior Court.
Speaking for the juvenile,
I would like to think juvenile court judges are much smarter and would never do that.
well, speaking from strictly our standpoint, I think our greatest concern was the second provision that required the appointment of a counselor. Because the question, who was going to pay for it, is that still in the statute or in the amendment, or has that been taken out?
That's been taken out from the bill.
I think that was the only concern that we really had about the bill.
Yeah, well, and our Superior and juvenile court judges have the option of ordering evaluations and different things like that. So, that's currently within the judicial discretion right now. There's not, I didn't see any reason to duplicate that within the confines of the bill.
And in every juvenile court case, we either have CASA or guardian ad litem that's already making best interest recommendations. We have the authority, again, as you say, to bring a counselor into it if we feel it's necessary, but we just didn't like that shall language. So if that's been taken out, that would address the concern that we had.
Yep, that's all gone.
Thank you.
You're welcome.
Read the amendment to them so they can see what it would be.
Okay, let me kind of finish going through it. So section 3, number 12. Okay, I think I talked my way into another question. Let me hush. Okay, section 3 now reads family reunification or unification treatments programs. I think I have already been over that as described in code section 1511-202.1. The other change, section 4 now reads down on lines 36 to 37, the judge shall not order family reunification or unification treatment programs or services, including but not limited to camps, workshop, therapeutic vacations, or educational programs that, as a condition of enrollment or participation, require or result in any of the following: violation of a court order requiring that a child have no contact with his or her parent or legal guardian, or the use of private youth transporters or private transportation agents engaged in the use of force, threat of force, physical obstruction, acutely distressing circumstances, or circumstances that place the safety of the child at risk. I'm going to have Brian read a second. This is going to be the first amendment to this bill, but before you entertain that, now that I have kind of gone through the bill, everybody kind of understands the policy and the reasoning behind it. Is there a motion on the bill?
Motion to pass.
Okay, we have a motion to pass. Is there a second? There's a second. So at this time, turn myself off. We will entertain, I'm going to have Brian read the amendment. This would be an amendment to the sub, LC 481514S.
Okay, so.
Oh, let me turn you on.
Oh, sorry.
There you go.
There we go. So this would be in section 4, and this would be adding 2 provisions to effectuate what Madam Chair was saying. So on the first thing would be to strike the or on line 41, just because we'd be adding 2 new provisions as to when the non-reunification could not be made or ordered. So it would be add a new subsection C that would add in some similar language to what was in the original bill, and it would say a no contact period between the child and his or her parent or legal guardian, semicolon or, and then it would be adding a D and says an out of state stay. And again, that's similar to what was in the previous version of the bill, just trying to make sure you can essentially go over state lines, or you can't have any time of a no contact period between the child and the parent or guardian.
So I think that just kind of clarifies things as far as the really kind of getting at the heart of the program and what we wanted to do. I'm sorry, D. Will you reread D,
Sure.
please?
Sure. So D would say an out of state stay when they're in the period.
So I will make the motion. We will refer to that as Amendment A. We're adding C, the no contact provision, and the D, out-of-state provision in Section 4. So we would basically be adding a couple of lines at the end of 44.
Second the motion.
Okay, second the motion. All those in favor of emotion. Ooh, deal. All those in favor of the motion A for LC 481514S, please signify by saying aye. Any opposed? Like sign. Okay, we have the amendment. So now we have before the rest of the committee passage of House Bill 253, LC 481514S, as amended by this committee. We have a motion, we have a second. All those in favor of this motion as amended, please signify by saying aye. Any opposed? Like sign. Bill passes. Thank you, thank you, Mr. Clark, Representative Clark. And I will sign off on the sheet for you. And we will also, anyway, I'll sign off on both the forms that you need. And having no other business before the yes, you have a question?
If I could just say thank you to the committee. This is what it's about, like coming before the committee with the bill, refining it, working on it, and I love the substitute, so thank you so much.
Thank you. We like to make things better here in Judicial Juvenile. So anyway, with that, we are adjourned. Thank you.